today is the 8th of April 2021, and we will be looking at the legal framework for limited liability partnerships, and thereafter hopefully we will also look at the legal framework for limited partnerships. Like I said, we'll be doing more of an overview, and if we have time we will cover one or two things I did not cover yesterday when we looked at arrangements and compromise. So I will try and give us just an overview of the legal framework for limited. We'll start with limited liability partnerships, and after that we will look at the legal framework for limited partnerships. Okay, so what is the LLP? What is the LLP about? Just a second. Okay, so yeah. Okay, so the LLP is a new addition to our legal business forms. We have always had a company which we all know about, and we've also always had the partnership form, the general partnership form, but we now have another form or legal business form or legal business entity that has been added to what we had before, which is called the LLP. The limited liability partnership is a hybrid. It's an entity that is a hybrid of aspects of the company and aspects of the general partnership. So it is an entity that contains some of the features of both of these entities. It was first of all introduced. I've already sent us the slide, so you don't really need to copy. The slide is already been given. But it was first of all introduced to the United States of America in the year 1991. Yes, 1991. You know, in the US there was a problem called the savings and loans debacle. What happened was that a number of savings companies that are involved in savings, household savings, loans and all that, they went bankrupt around the middle of the 80s, towards the end of the 80s and the early 90s. And when they went bankrupt, the persons who lost their funds, persons who had invested monies in these financial institutions, sought to recover their funds from these entities, but because they were bankrupt, they couldn't do much. So they decided to go after the professionals who provided advice to them and who worked for them, the lawyers, the accountants, the auditors, as the case may be. And so a number of these professionals who operated through the partnership form found themselves being exposed to liability for negligent professional advice. So basically that under the partnership form, all the partners will bear unlimited liability. And so if myself and Mr. Prosper, we have formed a partnership and he renders a negligent professional advice, I would also have to bear unlimited liability to any third party who suffers as a result of that act. So after the loans and the savings and loans debacle, there were a number of actions that were instituted against these professionals, and so they found themselves exposed. They found their personal estate exposed, not just for their personal wrongdoing, but also for the wrongdoing of their fellow partners. And so it was felt that there was need for the conferment of some extent of protection on persons who traded under the partnership form to shield and protect them from bearing unlimited liability. Are you with me?
Yes.
The question one would want to ask is, couldn't they simply have operated through the corporate form? They couldn't have just operated through the corporate form because there is one basic limitation partners have in operating under a company. The major limitation is that for partnerships, particularly professional partnerships, they are often regulated by their own professional bodies. And these professional bodies will, among other things, require that they do not intermingle with non-professionals. Classic example is NBA, Nigerian Bar Association. So if we are going to set up a firm of lawyers, lawyers are prohibited from entering into a partnership with non-lawyers. The same will apply to medical doctors, to accountants, estate surveyors, as the case may be. Why is this so? Because the Nigerian Bar Association, the Legal Practitioners Disciplinary Committee, and all the other related bodies that regulate the legal profession, the General Council of the Bar and all that, they will not be able to regulate non-lawyers who operate with lawyers in the practice of the profession of law. Are you with me? Yes. Are you with me? Yes, so they will require that if we are going to have a law firm, that law firm should have only lawyers as partners. And so if we have 5 lawyers as partners, they will not be able to operate under a company, because among other things, for the company, there is freedom of transfer of shares. And so if 5 of us set up a company, nothing stops me from transferring my assets to a non-lawyer. Are you with me? Are you with me? So if I'm broke, people like us don't get broke. If I need money,
yes, amen.
What I will do is that I can call a non-lawyer and transfer my interest to him. He takes over my place. So we have 4 lawyers and a carpenter are now partners. Are you with me?
Yes.
By so doing, I have disrupted the partnership form. But so in order to regulate partnerships, most bodies that regulate professionals, I'm not talking of every partnership, but professional partnerships often require that only persons of that particular profession should be involved. Mr. Sufi, I hope you are clear.
Very clear.
Excellent. And so that meant that if 4 or 5 persons are going to operate through a partnership, I mean, if they want to form a partnership, then they have to do that through a business form that places a major restriction on membership. Through a business form that places a restriction on membership, and that business form is a partnership. Because if 2 or 3 persons come together to form a partnership, one of the major conditions is that Bekowe cannot bring in a 3rd person to join. Are you with me? If all of us do not agree. And so Bekowe cannot arise and tell me that he has brought in his younger brother, he's traveling abroad, his younger brother is going to replace him. And if his younger brother is not a lawyer, there's nothing we can do, we must accept him. For the partnership, you can't do that. Because the moment you transfer your membership right to another person, you have by default dissolved the entity. Are you with me? And so that made the partnership to be relevant all these years. The general partnership has remained relevant because, among other things, it was the only way through which professionals could carry out their business under a regulated form. They couldn't do that through the company. I've been trying to emphasize one fact. But the challenge was that in carrying out the business through the partnership, every one of them had to bear unlimited liability. And so that was the snag. Are you with me? So if we have 5 medical doctors operating through a partnership, and one of them mistakenly forgets a scalpel in somebody's body, and the person is now in pains and travels to Germany and discovers that your former doctor somewhere forgot a scalpel inside your body, and the person returns to Nigeria and institutes an action. It's not just instituting the action against that particular medical doctor, but all the doctors. And so that was what gave rise to these actions, in the United States of America. And so going forward, it was now felt that we should have a business form that, number one, like I said, places a restriction on membership, but at the same time confers upon the members who trade upon that entity limited liability. And so we now have the LLP. So originally, the first LLP that was introduced in the state of Texas, in the US state of Texas, it was actually introduced as a result of an amendment to the Texas Uniform Partnership Act. Texas Uniform Partnership Act. Are you with me? Are you with me so far? Yes. And that law only conferred this protection of limited liability to partners who traded through professional partnerships. Not every partner. You know, not every partnership is a professional partnership. You know that. So when we're talking about professional partnerships, we're talking about persons who belong to regulated professions like the practice of law, accounting, medicine, surveying, engineering, as the case may be. Are there questions? Okay, so let's move on then.
Yes, sir.
Yes, please.
I said, it confers upon the members what?
Limited liability.
Okay.
Yes. And so what we now have in the LLP is that two or more persons can come together. I'm giving you an overview. I cannot spend all the time and go into details. Two or more persons can come together and incorporate this entity. They don't just register it, but by registration, the entity becomes incorporated. That is why it's like a company. Are you with me? If you register your business name, registration does not confer it with incorporation. But if you register a company, registration confers upon it incorporation, which means it becomes a legal entity of its own, capable of suing and be sued and all that. And so that same idea is now incorporated into the LLP. That once two or more persons come together and register an LLP, upon registration, the entity becomes a legal person, separate from its members, capable of suing and be sued, and the members of this entity all enjoy limited liability. That is the major provision. Now you may ask, what is the difference between this entity and the company? That is the first thing, because you appreciate the LLP more when you compare it to the company. For the company, the capital pool is always meant to be reduced into shares of a fixed amount, quantifiable in monetary terms, in order to enable transfer. Are you with me? Every company must have, apart from the limited, the guarantee company of course, every company must have a capital base, stipulated, minimum is stipulated by law, at least in Nigeria, and it is reduced into shares, quantifiable in monetary terms, in order to enable transfer. And so the moment I buy shares in a company, invariably I can transfer those shares to a third party. There may be restrictions in the case of private companies. Public companies, no restrictions. But for the LLP, the capital pool is not reduced into what? Shares. That already tells you that transfer itself is not going to be easy. Because for this entity, we do not envisage free transferability. Another thing you notice, another distinction between the company, I love the number of distinctions, is that for the limited partnership, the limited liability partnership, the LLP, the law envisages that this entity should be able to operate with the internal flexibilities of the partnership, although it is clothed with incorporation. For the company, the company is not generally meant to operate as freely as the members want to, and that is why we have a barrage of sections from section 18 up to section 700 and something, or maybe 700 and something, dealing with how we regulate the company. But when we come to the LLP, we just have maybe 20 or 25 sections. Why? That is deliberate. Are you with me? So the LLP is meant to operate with flexibilities, internal flexibilities of the partnership. So the aim of the law is not to regulate every aspect of this entity. For the company, yes, we want to do that because we are looking at creditor protection and the protection of third parties and all that. Another thing you will notice again is that for the LLP, because like I said, it incorporates aspects of the partnership. For the LLP, every member is deemed to have a right to participate in management. For the company, of course, you know that management is separate from membership. Companies must appoint a separate group of persons called directors to manage and direct their affairs. And these persons owe their responsibility primarily to the company and not to the persons who appointed them. When we come over to the LLP, there is no such requirement for management. There may be, but it's not mandatory. Are you with me? Are you with me? And so,
are those directors also professionals?
For companies,
for the appointment, for those to be appointed.
No, they mustn't be. When we talk about that, directors of companies must not be professionals.
Because of the partnership.
For the partnership, the LLP is not only dealing with regulated professionals. I was looking at the history when we went to Texas, and I was saying that originally it was targeted at protecting regulated professionals. But over time, they have now evolved, the law has evolved to now incorporate every kind of person. So 2 groundnut sellers and 1 shoemaker can come together and operate under the LLP form. But originally it was geared towards conferring this protection on regulated. And even in some countries like Canada, up till now, the LLP only applies to regulated professionals because that was the original intention. Can we continue? Okay, so partnership before Kama, you all know about it. Unlimited liability, absence of corporate personality, and the partnership could be easily dissolved by notice, by death, by bankruptcy. So the partnership was a loosely regulated entity that was regulated by the Partnership Act of 1890 and aspects of the law of contract, and among other things, there was unlimited liability. So there was nothing like limited liability. Every partner was deemed to also have a role in management. By default, if a partnership has 20 members, every partner will be deemed to also have a right to be involved in management. But we all know that limited liability became very, very unattractive, particularly after company law now made unlimited liability, made the partnership very, very unattractive, particularly after company law made limited liability available. And furthermore, in 1908, we now had a private company. So why trade through the partnership when you can trade through the what? Through the private company. I hope you people are with me.
Yes.
Any questions, please? Do I come again? Do I come again? Yes.
Kind of.
What I'm trying to say, please, I'm trying to say, let's first of all look at what existed before the LLP. What existed before the LLP was that we had the partnership form. And we are saying that the partnership was an entity where the members had unlimited liability. And because they had unlimited liability, it made the entity very unattractive. Because if 2 of us set up a business, and I am in Owerri and I hear that you have gone to do something wrong in Ogbia here, they can come and sue me. Because by trading through a partnership, you impliedly pledge the whole of your personal assets to the liabilities of that company. That is the whole idea of unlimited liability. So if I have 1 billion naira in the bank, and I'm now trading with you in a partnership that just where my contribution to this entity is just 100 naira. Your contribution is 100 naira. So the business is being run with 200 naira. And something happens. The entity now incurs a significant liability to a third party. My 1 billion naira is by implication pledged to that entity. That is the whole idea of unlimited liability. And so the more partnerships I traded under, the more my personal risk of liability multiplied. So if I am a partner in 10 firms, it meant that my personal liability to being, my personal funds are being pledged to satisfy the liabilities of those 10 firms. That is very unattractive, particularly if I'm not the one managing the entity. I hope you are with me. Yes. And so this meant that persons who intended to trade opted, rather than go through the partnership route, to use the private company, because the private company that was introduced from 1908 introduced a number of relaxations or reliefs for the entity, which meant that if we are going to trade through a private company, we will not have to be subjected to the barrage of liabilities, the barrage of obligations, which the public company was meant to comply with. Are you with me? So why go through the partnership? That's what we are saying. And so the partnership became almost extinct, but it continued largely because of professional partnerships. Because professional partnerships could not trade through the company, primarily because the regulators of these professional partnerships required that they should trade through an entity that does not make room for a third party who is not a member of that profession to be a co-partner. I have said all that to say this. If you still don't understand, spend time in prayer. Light will come. Possibility, wake that Oga for us. Can we proceed, please? Yes, okay. So let's just run through some of the features of the LLP. Let's run through some of the features. Let's talk about management. Let's talk about management. I was talking about the company, that the company must have a board. For the LLP, it's not mandatory. For the LLP, it's not mandatory. Rather, what the law requires is that the partners must appoint at least 2 persons called designated partners. That is all that's required. Select 2 among all of you. So if there are 10 partners operating under an LLP, 2 persons must be designated as designated partners. Their role is not to manage the entity, but their role is to ensure that the entity complies with filing obligations, compliance obligations imposed upon the entity by CAMA. Are you with me? So the entity, the LLP, is required, among other things, to file an annual return. And if there's an order of court in relation to some of its transactions, ensure that you file those returns, file those orders with the Corporate Affairs Commission. If a partner is changed and you have a new partner, let CAC know. Are you with me? Yes. All those obligations, CAMA is now saying, who is going to ensure that those obligations are met? For the company, we know that we must have directors, we must have a secretary, we must have officers. So if those obligations are not met, we can hold the directors. Is it not so? We can hold the secretary. But for the LLP, because we want it to operate as flexibly as possible, like a partnership, we have removed every obligation with respect to management. But in removing that, we fall the risk of non-compliance with statutory obligations. And that is why CAMA is now saying designate 2 persons. Those persons are called designated partners. And so upon them, we are imposing all the obligations with respect to filings and these statutory obligations. If we fail to do that, then the law is going to deem all the partners to be designated partners. And so if there is failure in filing, all the partners will bear liability. I hope we are clear so far. Excellent. Let's move on, please. Okay, so incorporation, how do we incorporate the LLP is very similar to the company, but while the company must have a memorandum and an articles of association, Rebecca, thank you. While the company must have a memorandum and articles and a number of these other documents, for the LLP, what we basically need is a document called the incorporation document. Are you with me? Yeah, incorporation document containing the names, the objects, and all that. And after that, the Corporate Affairs Commission will register and issue a certificate of incorporation, and then basically that. Okay, so again, provisions with respect to the name of the LLP are similar to what we have with the company. You know what, sections 30, sections 31 of CAMA, the name must not conflict, the name must not violate, or a number of those provisions are also applicable here. In fact, when you look at sections, when you look at the provisions in section 757 to 760, the provisions relating to the name of the company in part B, which deals with companies, are applicable to LLP. So all those provisions we know about the name also apply here as well. The only thing we want to add is that every LLP must have at the end of each name LLP, just like we have LTD and we have what else? PLC. Excellent. So for this one we must have LLP at the end. Again, I talked about the agreement. So while we have the memorandum of association and the articles of association, here we have the partnership agreement, which definitely is going to regulate the affairs of the parties among themselves. So everything you want to talk about profit sharing and all that must be contained in the partnership agreement. However, if you look at Schedule 15 of the Act, Schedule 15 of the Act contains a number of paragraphs which apply by default. So in the absence of anything in the agreement, then Schedule 15 will apply. So Schedule 15, for example, provides that every partner will be deemed to have an involvement in management. Every partner will be deemed to have equal share to profit in the event that there is dispute among the members. Then this is how we are going to address it and all that. So all that is contained in the 15th schedule, and they apply in the absence of anything in the partnership agreement. Are there questions so far?
No, sir.
Okay. In the S. So again, if you look at the Schedule 15, disputes, I talk about dispute settlement. Under the schedule, if there are disputes, they are to be resolved among the parties, and if they fail to do that, then they may have recourse to arbitration as the case may be. Membership in the LLP, just like the company, is open to everybody. So an LLP could have companies as well as individuals. So it mustn't just have individuals. That's what we're saying. It can have individuals and it can have corporate members as well. But for individuals, they mustn't be bankrupt, they mustn't be of unsound mind, and there must be a minimum of 2 partners. One thing you notice here is that the limitation with respect to age, that we have for the company is not applicable in the LLP. So for the company, a member mustn't be less than 18 unless there are 2 competent members. You remember?
Yes.
Yeah, that limitation is not here. So it means that 2 or 3 persons who are 16 or 15 that decide to set up or register a business may want to opt for the LLP if they are underage, rather than probably operate through the company. Yeah. Can we continue? Okay, so section 763, again for cessation of membership, cessation of membership. Similar again to the partnership. You cease to be a member by resignation, by death, insolvency, and all that. Insolvency. But you know, for the company where you cease to be a member, your shares, if you cease to be a member, for example, as a result of death, are automatically transmitted to your personal representative. Is that not so? Yes. That doesn't apply automatically in the LLP, because like I told us, the idea of the LLP is for an entity with some level of restriction on the number of persons who can be members. You know, so upon the death of a person or upon the person becoming bankrupt, his interest do not transfer automatically to another person. Again, the person may get agitated, he doesn't like the way the entity is being managed, and he decides to resign. But upon his resignation, he already had money in the entity, he had invested. Let's assume the entity has 100 naira, and he had invested 40 naira in that capital pool. And he says, I'm not doing it again, I'm resigning. For the company, you don't really resign, apart from the guarantee company. For share capital companies, there's no provision for resignation of membership. Are you with me? Are you with me?
Yes.
You transfer your membership. Sorry about that, Stella. You transfer your membership or you sell. Is it also?
Yes.
But for the LLP, you can resign. I say I'm no more a member again. I don't like everything that is going on. But what happens to your funds there? So we'll talk briefly about that when we come to former partners. Okay, we're already there. Okay, so section 763 has some provisions with respect to former partners. So this person is no more a partner. He could be expelled. So under the LLP, you could expel a partner if the agreement so provides. If the agreement so provides, you could expel a partner. But that doesn't affect his investment in the entity. You know, so a former partner will still be entitled to profits. He cannot have any involvement in management, of course. And but if his investment in the entity is yielding fruit, then definitely he should still be entitled to profit. Again, liability that he incurred, liability that was incurred by him before he resigned, he will still have to bear liability for them. It's not
Within 1 year.
It's not like the company.
Okay.
You know, in the case of the company, 1 year after you cease to be a member, then you cease to bear liability.
Okay.
But for the partnership, even 100 years after, you continue, because there were liabilities that you had become obligated to discharge before you resigned. I don't know if you understand. Yes. Either you were owing the partnership entity itself, you were owing the other partners, or you were owing third parties. In either of these instances, liability that you had incurred to any of these three before you resigned, your resignation does not absolve you from them. Even Annabelle is sleeping. What is happening in this class? I beg you. You are sleeping. It means that I have to go back and check whether my anointing is still working. Can we continue?
Even if he had paid for his shares.
No, yes, that is the issue here. For the LLP, your liability or the absence of your liability is not tied to your contribution. For the company, your liability is tied to your shares. Are you with me? You pay for those shares, you can go scot-free. If you've not paid for those shares, we can call upon you. For the LLP, there are no capital contribution provisions. Your liability or the absence of your liability is not necessarily tied to a capital contribution provision. But for the company, it is. You must be issued shares, or you have been issued shares, and you have to pay for them. For LLP, shares are not issued. So the three of us can come together and form an LLP. There's no provision in the law that entity must have 200,000, 500,000, 1 million, as the case may be. Are you with me? And so all the assets we may have may be the understanding that we have in our brain. And so we start to trade. But if in the course of trading, I now become liable to the partnership entity itself. I want to pay my son's school fees. Please, I don't have enough money. Can you borrow me? And so the entity borrows you. That is a liability that is already in existence. My resignation from the entity will not absolve me from that. I work out my sin. Yeah, so resignation does not absolve you from liability to the entity, to the partners, or to third party. And I already said that when you resign, and you don't have any right again to interfere in management. Okay, let's move on. Okay. Okay. Yeah. Yeah, there's another thing I want to point out. Third parties who deal with a former partner in good faith will still be able to proceed against the LLP as though they knew. A third party who deals with the LLP in good faith. Who deals with a former partner in good faith. So if a former partner has left the firm, then the firm would have to protect itself. The firm should go and notify CAC that Mr. Prosper is no more with us. He has moved on. Are you with me?
Yes.
He has moved on to a higher level. Once you file that notice, you have protected yourself. So the third party now who is going to extend money to him is doing it on his own risk. Are you with me? If you don't file that notice, a third party who extends money to him in good faith, on the presumption that he is still a partner, only to subsequently discover that he has moved on, will be able to sue us. So that is the whole idea so please.
If the person now says there was no disclaimer, there was no publication.
Yes, that filing of that document with CAC is the disclaimer. Once the company has gone to file the document with CAC to say Prosper has moved on, then it behoves on the third party to beware. That's why you say buyer beware. So the presumption of constructive notice will bar that person. Are you with me?
I am.
Yes, so it is now his own obligation and duty before dealing with Prosper to first of all go and check with CAC, or he could call us and say, is Prosper still with you? We say Prosper is still with us, in which case of course we will be stopped from denying the contrary subsequently. Let me hear you.
Yes, sir. You said, if I don't know if I got you right, that the person who has resigned from the LLP can still share and still benefit from his contribution.
Yes, they can.
So would it not be better to give him back his capital than
that should be ideal.
Because he's still statistically a member of the
Ideally, yes, good question. So, like I said, this is one difference between the LLP and the company.
Yeah.
For the company, once you have sold your shares to a third party, you are out. For the company, you do not resign. You don't resign. Apart from the guarantee company, you don't resign. For the LLP, you can resign. I am no more a partner. And so upon resignation, definitely there will be two options. You may demand for your money that you invested to be given back to you. You may say continue trading. No problem. Continue trading and continue to pay me profits as they are due. So that is what Kama is saying. Yes, so there are options. Yes, please.
So what is so attractive about this LLP? If I cannot transfer my assets, maybe if I'm dead,
yes,
that my children cannot come to benefit from this.
Good question. If you are no more, your children can benefit. That's what we are saying. You can transfer your rights to the profits that you already had. So 3 people come together and form a law firm. Are you with me? And they have now quantified their contribution, because the contribution to the entity could be in monetary terms, it could be in service, it could be in anything. So let's assume that the entity now is worth 1 billion naira. And let's say there are 3 of them and it's worth 90 billion. And your contribution to that capital is 30 billion. If you die, your son or your daughter replacing you mustn't be a partner. That's what we're saying. But that your son or your daughter can benefit from that 30 million. Are you with me? Are you with me?
Yes, sir.
For the company, upon your death, 2 things will happen. Your son will take your place. And so he's taking your place will give him 2 rights. Number 1, a right to profits. Number 2, a right to management. Are you with me? A right to be involved in the operation of the entity, either in his capacity as a member or whatever. For the LLP, upon your death, your son who takes your place, number 1, upon your death, your son has no automatic right to take your place without the consent of the other persons. So the other 2 partners can come together and say, this is son is a worthy son, he's even a lawyer. Are you with me? Yes. So let him replace his father. They could say, no, we don't want any other lawyer, we don't want any other partner, so let the 2 of us remain. But your 30 billion, your son will have a right to it. Are you with me? Yes, the profit or whatever comes out of it. So let's assume that the entity has, that 90 billion was used to buy a property. And people are renting that property every year. Are you with me? Yes. And they are paying 90 naira every year. Your son will continue to benefit from the 30 naira, as your portion. But he cannot now say, you must replace me. But for the company, that your son can go to the court and the court will give an order. Put his name in the register of members. So that is why the LLP is attractive, because it will allow us to carry out our business with only persons of like mind, persons we know and agree with. Yes, while also benefiting from limited liability. Yes, Mr. Kolokolo.
So, sir, with your explanation, that means in the LLP, one can benefit without necessarily being a member.
Yes, a former member. We're looking at a former member.
A former member, mostly yes. With the demise or with the resignation of the person.
Yes. Yes, sir.
You can benefit.
You can continue to benefit. Okay. I can resign and still continue to benefit. Yes, please. Any other person?
Now, what if the person was expelled?
Yes, even if he's expelled, he continues to benefit. Let me take Richard. Richard has never asked questions. No, let me hear from you.
So is it that if the former member did not take back his capital contribution, his entitlement to the profit is perpetual?
Yes, as long as the entity remains a going concern, as long as it remains a going concern, he has an entitlement to benefit from what he had invested in the entity before he resigned. Is that Ikato? That's my. Why is that his name again? Enato. You were not here last week. Is that not Enato? No. Where is Enato? He has missed 2 classes. He's not feeling fine. It's well with him. What is that man's name? Happy John. Can we continue? Yes. Wokoro was raising her hand. No, sorry. And Gessi. Azi. Okay. Any other question? Yes, my dear. This one that Stella is asking questions today. We give God praise, oh.
Okay.
Yes.
You said something about the limited liability partnership that you can actually withdraw from it and say that you don't want to be part of the partnership.
Yes.
So is that like a difference between it and the company? Because in company there's like the surrender of withdrawal rights. You cannot say you're not part of it. So can I say that's a difference between partnership?
In a way, yes. Thank you for that question again. For the LLP, because what we want to see now, you can see the next slide is creditor protection, which is actually what you're trying to say. For the company to protect creditors, the law has told us, capital once contributed cannot be withdrawn while the entity remains a going concern. We don't have such protections for the LLP. What it implies is that upon resignation, a partner resigning can insist and demand that his capital contribution be returned to him. And if such funds are available, they must be. And if not, he can sue for them. Are you with me?
So why is this still limited liability now?
The protection is only for, the protection here is basically for the persons. Entity protection exists, yes. Entity protection, what we call entity shielding, exists, but in a narrow sense. I will explain. For the company, once we establish this entity, these are its assets. These assets are shielded by law from two groups of persons. Number one, from the partners themselves, from the members themselves. Number two, from their personal creditors. So if I have formed a company and I have put my funds into this laptop, while it is a going concern, I cannot return, I cannot take those funds back to myself. That is what entity shielding is all about. Number two, if I'm owing Prosper John cannot proceed against this laptop. Are you with me? Yes. The highest that can happen is that if he gets judgment against me, he can ask the court to transfer my rights in this company to him. When we come over to the LLP, we don't necessarily have such protections. What it means, first of all, is that if myself, Mr. Sufi, and Prosper, we set up an LLP, and this is its entity, this is its capital or its assets. The day the three of us want to dissolve, we can dissolve and share this entity. That is one. Two, even while the entity is a going concern, are you with me? As Mr. Sufi says he needs money, Prosper says he needs money, I need money. We can sell this laptop. The business is still a going concern, but we have sold the laptop and we are happy. For the company law says no, you can't touch this laptop. You can only touch what we have used this laptop to benefit from, which is what we now call distributable profits. So we can touch the distributable profit, we can't touch the capital. For the LLP, the law says you can touch it. Where then is entity shielding in the LLP? Entity shielding exists in the LLP to the extent that if myself and Mr. Sufi and Mr. Prosper, we have set up this entity with this something now, this is our business. His own personal liability, his own personal creditors, are you with me? Cannot just come and say they are taking this. So the three of us must consent. Are you with me? If the three of us do not consent, then his own personal creditors cannot proceed against this. So the business has some level of protection from the personal creditors, of the partners, but it does not enjoy protection from the partners. Are you with me? For company law, the protection is dual, is double. And so you can only proceed against this asset for company law if you are a direct creditor of the company itself. Then yes, you have an unrestricted approach or access to assets. Yes, please.
But sir, in this case, so the managers of these LLPs cannot borrow money to run the business.
They can.
So if they borrow money now,
yes,
and the company is insolvent,
yes,
can a partner or a pre-solvent action
yes,
remove his money, and maybe removal of that money can cost
jeopardize the interest of the creditor? That's why we're saying that we don't have adequate creditor protection for LLPs.
Okay.
And so any person who is going to extend funds to an LLP would have to require greater protection by relying on contracts. Either by, first of all, relying on securitization. I need a secured credit.
So in this case, why is it attractive?
It is attractive first because of the protection. It's attractive from the perspective of the partners.
Just the partners.
The partners, yes. Because it allows them to operate with limited liability. The three of us have set up a partnership, a professional law firm. I have gone to Gwarimpa in Abuja I'm there for 1 year. This man has now incurred liability. The creditors of this partnership cannot come and seize my house in Gwarimpa. So it now frees me from the unnecessary obligation. Richard, are you with us? It frees me from the unnecessary burden of being overly conscious of what this entity is doing. If it was an entity that did not have limited liability, as I'm in Gwarimpa, my heart will be beating. What has Prosper done again? Because whatever he does, I will have to bear liability for it. So that is the first protection. So it shields professionals. There's a snag which we'll talk about lifting the veil in a sense here. The shield, the protection, does not extend to personal wrongdoing. Personal wrongdoing. So if 3 medical doctors have set up this entity and it's an LLP, and Dr. A now gives a wrong advice, Madam, wait till you carry the no be pikin o. Madam, that is like cancer, flush am. But it's a child. It's a baby. And they have been waiting for the baby for the past 19 years. The woman now say, na cancer. Say flush am quick before it grow. She now goes to flush it out, only to discover that it was a baby. Partner B and C will not bear liability. But the protection of limited liability in this case does not extend to personal wrongdoing. Okay. Yes. It only applies to basic contractual obligations, contractual liabilities that the entity has incurred in carrying out its normal business. Yeah. But it does not apply to wrongdoing. Yes, please.
There was a particular case that happened, especially the News Watch magazine. They were a team of journalists that came together. They had an idea of forming maybe a company. And they did not have the capital. And they now went to one Jimo Ibrahim for a capital, and the man advanced in the capital. And at the end, the company was to be, maybe there was a crisis. And Jimo Ibrahim took them to court. And before you know it, he took over the assets and everything of the company.
Are you telling
so I'm still wondering how this LLP will work out in this case, in connection with a creditor who is not even a party to the district.
A creditor, there are a lot of protections that creditors can rely on to protect themselves. Are you with me?
Yes.
Yes, and so all they need to do is to consult a lawyer or to take the adequate steps to ensure that they protect their interests. If they fail to do that, then they will have to, there's nothing else that can be done. Any other question before I continue where we were?
So, sir, what if the member resigning is the money bag in the partnership, and him resigning and withdrawing his cash will tend to just crumble the whole partnership? They will let him go.
Yes, it depends now. You may be resigning. Yes, there's nothing else you can do. Are you with me? Again, the LLP is, it doesn't have the kind of life that the company can have, because, like I said, for the company, there's a surrender of withdrawal rights. For the LLP, there is no such. There is no such. And so, a partner resigning can insist that the assets of the entity be sold, because the focus of the LLP, please listen, the focus of the LLP is not to protect creditors. The focus of company law is to protect creditors, employees, and other persons that may find themselves as being vulnerable to the abuses of limited liability. Are you with me? Yes. Please, thank you. God bless you. God bless you. But for the LLP, the focus of this entity is to protect the professionals. That is why I told you that the original intention was geared towards protecting professionals. For the company, please listen, for the company, we confer limited liability in order to enable this entity to attract large sums of money to drive the economy. LLPs are not designed for large businesses. That is why they don't sell shares. Are you with me? They don't sell shares. There are no major capital requirements. Rather, we have 2 or 3 persons who want to operate as professionals, but they want protection. They want protection because the liability that you can bear. Imagine the instance I was giving now, the medical liability, the cost that the court may award may run up to, let's assume it's 200 million, and somebody may find himself totally what? Bankrupt for no fault of his. Are you with me? For no fault of his. You may have a cousin who says, I love your CV is rich. Please, I'm trying to set up a firm in Abuja. Since you are not really doing much, or Kevin, you are going to America now. Please, the firm I'm setting up, let me add your name. Just listen. Let me add your name. And so he adds the name, Kevin, blah, 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 LLBPL, whatever. Adds all the qualifications to boost the profile of that firm. Kevin is in America. If we don't confer protection on him, and that firm in Abuja goes to defraud somebody, as it's in America, we proceed against him. So the focus, LLP focus, is on the parties to enable professionals to operate. When we move over to the company, the focus is on the parties, not on the members, not to enable them necessarily to operate, but to enable this entity to amass funds from scattered investors. Are you with me? Yes. And so a company can have as much as 200,000 members who have plowed in their funds, and they don't want to be involved in management, neither do they want to bear liability. And so we should protect them. Because if we don't protect them, persons will not plow their funds into companies. And if they don't plow their funds into companies, our economy will definitely be affected, because economies are sustained by private enterprise. So the idea is different. And that is why for company we have so many provisions relating to capital. For the LLP, next to 0. Because we are looking here at 2 or 3 persons coming together, not necessarily to drive business, but to drive a professional skill. And so that is why in some countries the LLP is only for professionals. It was to be like that also in England in 2000, but they had an issue to now define who is a regulated professional. You know, should we limit it to lawyers, accountants, and auditors? Are these the only regulated professionals? What about estate surveyors and all that? In the end, after much argument, they say let's just blow it open. And so England decided to blow it open to all persons. So it's an all-comers affair. But the original intention was for regulated professionals. And Nigeria decided to follow the English route by blowing it open. One more question, then I will jump in. Yeah? Okay, so it's like you guys are a bit tired today, but we will soon be done, eh?
3 classes. 3 classes.
Please, just give us. Yes, please, let me hear you.
So the practice of this LLP, are they truly practicable in this our environment in Nigeria?
Okay. Whether it is practicable?
Yeah.
Yes, it's very, very practicable. In fact, like I told us, Lagos State had already had an LLP law. Did I say that?
Yes.
What year?
No.
2009. Since 2009, no pidgin in my class, Mr. Alfred. Thank you. Not is there the material, it is in the
material. Worry boy.
Okay. So since 2011, Mr. Kolokolo, are you with us? Since 2009, Lagos had extended this protection to. It had been there in Lagos for years now, but the challenge was that they did not have the limited liability that Lagos decided to extend was very narrow. It was narrow because it did not apply extraterritorially, and so if that LLP carries out a transaction in Ondo State, all the parties will still bear unlimited liability. Derek, are you with us? It's well, though. It's well. Can we please continue?
Yes, sir.
Okay, so we're almost done. Talk about former partners. So see, please, creditor protection. Yes, so again, there's some level of lifting the veil here again. There's some level of lifting the veil. So please see section 769. 769, all the parties will bear personal liability if they are involved in fraud. And they may also face criminal prosecution. The firm itself may be struck out on the grounds that it is just unequitable to do so. And so please note the instance under which the company may escape liability. Okay. So there are just some provisions I want you to know. So please look at 770 and 771 for financial contributions, disclosures on accounts, and then transfers. So I told us before that transfer is possible, but if you are going to transfer, the other members must consent, and the person you are transferring to will not have a right to participate in the management or the conduct of the firm. So what you are transferring is your right to profit. The right to profit. Okay, so now, again, yes please.
What if they included it
in the agreement? Then of course it will be binding.
Agreement or still memorandum of understanding?
No, agreement, partnership agreement.
Partnership is agreement.
Once they include it there, it is applicable. Another thing I want to point out again is that aspects of the Partnership Act will also apply to the LLP to the extent that it will not be contrary and all that. Okay, so please look at section 775 to 77, minority protection. Most of what we had again in company law is brought here, investigation of companies and all that. Finally, winding up again, the entity can be wound up voluntarily. Again, unlike the company where the provision for liquidation is very so unlike the company where the procedure for liquidation is very robust, when we come to the LLP, the provision and the procedure is very, very easy. So the members can just wake up and dissolve it. Are you with me? For company, you can't wake up and do that. No. So it's more rigid and rigorous. And wake up that lady. In favor, please try and wake up, no sleeping. I beg you. Try your best. Look up. It's like you're even making calls there. This other auntie. Don't worry, you just have like 4 or 5 more classes and you won't be finished by Everman again. Bear with me for just 5 more classes. I will increase it though. We have basically 4 classes. Then I said I will do the last class, we just have some discussion. I will bring 1 or 2 lawyers. And so we'll not have more than 5. Can we continue? So I was trying to say that for the LLP is meant to be easy. In fact, when the LLP came on board, some people were saying that this form will displace the company, particularly for small entities. Why operate through a company when you can operate through an LLP? Why operate through a company when you can operate through an LLP? Are you with me?
Yes.
Because the LLP, like we said, is easier to dissolve. All the filings with CAC are virtually absent. You still have protection, liability protection. There's no even limit on the members. You know, for the private company, it can't go more than 50. Yeah, for the LLP, there's no such limit. Yeah, there's none. So the argument by some scholars initially was that the LLP has made the private company virtually useless. So I have written an article and I'm asking if the LLP is going to actually displace the private company. So in that article, I tried to compare the LLP and the private company. Are the advantages of the LLP actually more? You know, so I'll send it to you. It is being reviewed. It is under review, so it will be for. In fact, I will just print it. You know, I will not give you soft copy, because if I give you soft copy, you can spread. So I will print it and give it to you. You can consume it later, not necessarily for exam. Is it okay?
Yes.
Best, I can see how you're shaking your head. Okay, so basically winding up. So it can be wound up by the court. It can be wound up voluntarily. So these are some of the highlights. These are some of the highlights of the limited liability partnership. There are some issues which you may still want to look at. There's the issue of loss of publicity. Loss of publicity. Why would I want to trade through an LLP if I will still be required to submit my partnership agreement with Corporate Affairs Commission? So for the LLP, that loss of publicity is there. Then under what framework is the LLP going to be taxed? The profits of this entity, because now we say the LLP is a separate legal entity capable of owning property and all that. The profits of this LLP, will they be taxed under the CITA, Companies Income Tax Act, or would the profits of the entity be shared among the partners for them to be taxed under the Personal Income Tax Act? In the US and in the UK, the LLP is taxed under what they call a pass-through taxation arrangement. What it means is that the profits of the entity, although it is a separate legal entity, when it makes profits, the profits are not taxed as an entity. Rather, they are shared among the members, and each one of them will go and pay PIT, personal income tax. For Nigeria, it is not clear. CAMA doesn't make any such provisions. And I was expecting, we had a law called the Financial Act now, that the president signed about 4 months ago, December last year. I was expecting that that act would have also addressed the taxation of LLPs, but there is nothing about it. So for now, it is unclear. It is unclear under what framework the LLP will be taxed. So let's just rush quickly and look at the legal framework for limited partnerships. Can we do that? Yes. Excellent. So, yes, please. Yes, please. Somebody saying something. Yes, please, Kevin. Okay, so let's just rush through. This one should be shorter. I just have a few slides. Legal framework for limited partnerships in Nigeria. So what is the LP? What is the limited partnership? The major thing, Wokoro. The major thing about the limited partnership is that the limited partnership and the general partnership are virtually the same. So if you want to know the limited partnership, just know the general partnership. All that we have told you about the general partnership, it is not an entity of itself. All the partners can be involved in management. It can be dissolved upon the death, bankruptcy, agreement of the parties as the case may be. Are you with me? When we now come over to the LP, what the law has done is to say, yes, all the provisions applicable to the general partnership will apply here, but in this entity, we are going to make a little deviation by saying that when you are registering the entity, you must have at least one LP, which is called one limited partner, and one general partner. The general partner will not be involved in management of the entity. And because he's not involved in management, he will also not bear liability for the debts of the entity. The general partner is presumably involved in management, and by so doing, he will also have to bear unlimited liability. So we now have two sets of partners in the LP. One of them is involved in management, one is not involved in management. The one involved in management continues like the old partnership which we have always known to bear unlimited liability, and the other one goes home without bearing unlimited liability. My son, Come and turn it small so that the video will catch all those who are sleeping. Particularly that young man there. Turn the camera quickly. Let's catch him quickly before he wakes up. Why didn't you come quickly? Let's catch all those young people. Catch them in the video. Those who are sleeping. That girl that is chewing chewing gum, catch her in the video. Yes, that girl. Yes, let me hear Kevin.
Me catch him.
And everybody. Yes, Kevin.
So you say LLP has virtually made private companies useless?
No, it's an argument. It's an argument.
Okay,
Yeah.
Just make an argument.
Yes, I'm not saying it has. Some people
Secondly,
are
I would like to know the numbers of persons allowed in LLP. In numbers allowed
in LLP,
to form an LLP.
For the LLP, it's unlimited.
Unlimited.
Yes, you can have 1 million.
Okay, thank you.
You just said it now.
Can we continue, please? Yes, sir. Okay, my friend, you can focus back on the man. Can we continue, please? Yeah. Just give me like 15-20 minutes and we're done, please. So, this is a new entity. The LLP is actually not very new because England had provided for it as far back as 1907. 1907, the distinction between a general partner and a limited partner. The whole idea is that we should encourage the partnership entity to continue. What limited liability did when it was introduced in 1855 in England was to make the partnership entity almost irrelevant as a trading concern, almost moribund. Most people began to trade through the company. But we still had persons who wanted to trade through a smaller entity and did not necessarily desire to be subjected to obligations to which companies are subjected. Are you with me? So we should encourage such persons by also conferring on them limited liability. But there must be a condition. They mustn't be involved in management. If you are going to be involved in the management of an entity that does not, please listen. If you are going to be involved in the management of an entity and you want to have limited liability, then come and trade through the company. Come and trade through the company. Why? Because the company is better regulated. But if you are going to trade through such unregulated, in quotes, or a scarcely regulated entity as the partnership, then you must be ready to bear unlimited liability. So what England did in 1907 was to arrive at a compromise. Let unlimited liability continue to be imposed upon the general partner, but let's protect the limited partner. What does this mean? It means that I can extend money to a friend of mine who wants to set up a business. I desire to profit from that business. He wants to go into chicken business. He wants to set up a chicken farm, and he has the expertise. He doesn't have the capital. I know nothing about chickens. I have the funds. Are you with me?
Yes.
I can decide to extend him capital and go into partnership with him. Remember that if I borrow him money, I'll be a creditor. And my right to profit will be limited to my interest and capital. But if I join him as a partner, I bear the risk with him, and I stand to benefit from the business if he does very well. And so that is what the law did. And so that is what Kama has now done. Are you with me?
Yes, sir.
But in extending this protection of limited liability to the limited partner, the law also limits his rights. So when he's called a limited partner, he's called a limited partner from two senses, or from two perspectives. On the one hand, he's a limited partner because he has limited liability. On the other hand, he's a limited partner because his rights to the control or management of that entity, or his rights in that entity, are limited by law. Are you with me? Yeah, so let's just look at some of them. So see Part D of Kama, this is provided for in Part D of Kama. Just like the general partner, it mustn't have more than, it's a smaller entity, 20 members max. 20 members max. If it has more than 20 members, it must be incorporated as a company, otherwise the persons carrying on that business will have committed an offense.
Not more than 20.
Yes, please. Secondly, you must register. So registration is mandatory for any entity that is called an LP. Remember, registration is not mandatory for partners. Are you with me? Are you with me, Apam? If both of us set up a partnership business, we don't have to register it. We don't have to. But if it's going to be an LP, we must register. So I want you to know that. So LPs are not subjected to extensive and very detailed regulations and all that.
Sir.
Yes, please.
But we still have partnership.
Yes.
Then we have limited liability partnership.
Yes.
We have limited
Partnership, yes. I have written an article where I was asking, I think the one I sent you people today, I was asking the LP, is it necessary or is it an unnecessary proliferation of forms? Are we, you saw it? Yeah. Are we unnecessarily proliferating business forms? So you can look it up. Yes, Annabelle.
Sorry to take you back, but the first semester when we learned about formation of companies,
yes, please.
We said a company that has more than up to a certain amount of members must, an association that has more, a certain, I think 19 or something,
yes,
must incorporate that.
Yes.
Yes. But you just said LLP.
LP.
No, I'm talking about LLPs now.
Yes.
It said no restriction.
No restriction.
So I don't get it.
Yes, for the company, no, an unincorporated association. So you see that in section 19, section 19. Every unincorporated association that has more than 20 members must be incorporated. The LLP is not an unincorporated entity, it is incorporated. And so there's no cap, in this case, there's no cap to membership. The LP is unincorporated, and so it is caught by section 19 of CAMA. Are you with me? Once the members are more than 20, incorporate it. Incorporate it.
So the LP don't need incorporation?
It doesn't. The LP is not an incorporated entity. It's like a partnership. It doesn't have entity shielding. It's not separate from the members. It's just like a normal partnership.
Sole proprietorship?
No, sir. It's not a sole proprietorship because the sole proprietorship has only one member. For the LP, it must have 2 members. Limit of 2 mustn't be more than 20.
Okay. Limit of 2.
I think it's maximum. Please read. Yeah, not more than 20. Not more than 20. Not more than 20. Any other question? Annabelle, are you clear? Okay. So the LP. So please, I'm going to send you my slides so you just see some comparison between the LPs, limited partners, and general partners. You know, see some of the. So for the LP, let me give you an example. For the LP, the limited partner. So when we use LP, you have to know the sense in which we are using it. In one sense, LP, we are talking about limited partnership. In another sense, LP, we are talking about limited what? Partner. So the limited partner is limited indeed because, for example, he cannot dissolve the firm by notice. The general partner can dissolve the firm by notice. So if the 3 of us form a partnership, and I'm no more happy, I can send a notice, dissolve the firm. At any time, the firm is dissolved by notice. Death of one of the partners dissolves the firm. Bankruptcy and all that.
For LP?
Sir?
For the LP?
No, you know, for the general partnership. You know. But when we move over to the limited partnership, the law now says that man, please sit up, or you leave my class. Thank you, sir. Can we continue?
Yes.
Good. When you are in this class, take it as though you are in the court. Once you go to the courtroom, you are not allowed to behave any. Some of you have gone to watch proceedings, and you can't be making phone call. Yeah, you can't be going out to be coming like that. Are you with me?
Yes.
So you are in a sober environment. You can't be coming late. You keep coming late to. Once you are generally indisciplined, the judges are noticing. For you, some of you want to become judges. It is a judge that will recommend you as a judge. You know that. You can't be a judge unless judges recommend you. You don't know? Yeah, it's judges that recommend people to be judges. So once you have now taken the role of being generally indisciplined, the judge, the court is going on, is making phone call. Not the judge, you just notice. He always comes late. My car, my lord, I had flat tire. I have flat tire. I have flat tire. Every time I have flat tire. When it's time to recommend, yeah, this one is not serious. And judges always discuss, just like lecturers always discuss about students. Are you with me? Lecturers are discussing about students. Say, this one, don't mind him. This one, don't mind him. This one, this one is serious. We discuss about you people. You people don't discuss about us. You are pretending. We do, sir. You discuss about lecturers. That is how lecturers also discuss about students. Say this one has a future. There are some students that every lecturer is claiming to be my son. This is my daughter. This one and my daughter. Everybody is claiming when we are discussing.
Success has many benefits.
Okay, let's continue. So please sit up. Compose yourself. We're almost done. Okay, so what we are trying to say is that in protecting the LP, the limited partner, the law also limits the extent to which he can also affect the continuity of that firm. And so, unlike the general partnership, which is very vulnerable and can easily be dissolved, when we come to the limited partnership entity, there is a lot of limitations, or a lot of limitations are placed on the LP, the limited partner. He cannot manage and he cannot dissolve. Are you with me? He also cannot transfer his assets to another person without obtaining the consent of the general partners. He also does not have voting rights. Are you with me? So he is more or less just a contributor. That is basically who he is. He is more or less a contributor who participates in profits. He's a contributor who participates in profits. You can look at him from that sense. And if he decides to be involved in partnership, is there any penalty for him? Yes. I mean management. The moment he's involved in management, he loses his right to limited liability protection. So he loses his liability protection by becoming overly involved in management. Are you with me? So please note them. So what is the relevance of the LP? Like I said, it's very relevant to small businesses, and it can encourage me to give my money. It can encourage me to give my money to a business that I am not involved in management. And of course, it enjoys a lot of flexibility and confidentiality as well. Please, are there questions? Yes, please.
He said once the limited partner is involved in management, he will be sanctioned.
No, he will not be sanctioned, but he will lose that protection that we give to him. Protection of limited liability, in which case he will bear unlimited liability. So he should stay clear of involvement in management. You have given them your money to manage the firm. Allow the general partners to manage. Don't be unnecessarily advising. Of course, you can give advice, but if your advice becomes so undue to the extent whereby we can now interpret you as a shadow manager, you understand? They are meeting to discuss, you are there. You are always threatening them that if they don't follow this line of action, you are pulling out your money, you are doing this. We can now say, in fact, you are the manager. So you are enjoying limited protection, but you are the manager. They say, the law says you cannot eat both ways. If you want to manage an entity as well as enjoy limited liability, then go and trade through the partnership, through the LLP, or trade through the company. If you trade through the company and the LLP, then you can eat from both sides. You can be involved in management, you can still enjoy liability protection. But when we come to this entity called the partnership, anybody who is involved in management must bear limited liability. Why is that so? The reason is because the partnership is not stringently regulated like the company. Any questions?
Yes, sir.
Yes, please.
I still see a little discrepancy there. This is somebody who has got his money.
Yes.
The other person is mainly managing it.
Yes.
And he stands aside.
From management.
From management. So what encourages him then?
Good question.
Because at the end we are just trying to harass him into saying if you don't comply with this, leave this place and go and form your LLP.
Yes. What encourages him?
Or you go and form a company. So what encouragement does he have? He cannot control his money. He cannot his own investment. He will just wait. If profit comes, fine. If it doesn't come, okay.
Yeah, the encouragement he has, first of all, is that he is dealing with people he has faith in. So if you are going to deal through the LP, as a limited partner, the persons you are extending those funds to must be persons you trust very well. That is the first thing, very credible people, and there are people like that. You know, people that you can give your life to. So you are going to trade through such persons. Are you with me? Yes. What is the attraction of the LP? The major attraction is the flexibility. The flexibility, the confidentiality, the ease of arriving at decisions, and the fact that you are not subjected to a barrage of obligations. You can easily dissolve and take your money, and you have greater confidentiality and all that. But for some of us, we still wonder if this entity will prove to be attractive. You know, again, two companies may decide to trade through an LP or through an LLP, particularly the LLP, because for some time now, Nigeria has been trying to bring in what they call unincorporated joint ventures. You know, so NNPC and Shell are in a joint venture, what they call JV, but the JV itself is not incorporated. You know, so NNPC and Shell are in a partnership, but that partnership is basically what we call a general partnership. And Nigeria has been, or some people have been proposing that we should move to, Ken, all of you focus, stop disturbing the class. Please. So Nigeria has been trying to move to incorporated JVs. So the form like the LLP or the LP may prove attractive to two or more companies that want to operate through the partnership form. Because the LLP and the LP are partnerships, and so they have greater flexibility. Are you with me? Are you with me? So, for example, we have LNG, Nigerian Liquefied Natural Gas. That is a partnership, but it is a partnership that is being operated through a company. You know, but it's a partnership of Total, Shell, I think Chevron and NNPC. So now that we have these business firms, Shell and NNPC can decide to carry out that kind of a similar business through an LP, whereby we can have a general partner, and then the general partner could be Shell, that is the operator, and we could have NNPC. So these are some things, but we don't know how it will go. Let's see how it will work out in practice. Any other question? Okay, so please, we'll call it a day. I want you to go back and look at my slide on arrangements and compromise, particularly the last 3 or 4 slides, where I talked about the moratorium. The moratorium. Somebody was asking a question, I think from here, about creditor protection in arrangements and compromises. And I was trying to say that we'll get to it. So please, I've sent you the slides. Yes, creditors again can enter into an arrangement with a company. Remember, the first instances we looked at were instances whereby 2 or more companies came together to enter into these arrangements and compromises. But a creditor of a company can also enter into an arrangement with a company. And during the process of carrying out that arrangement, similar again to the CVA, a moratorium will apply for about 6 months or thereabouts. Are you with me? So I just want you to go back and take your time and look at it. So hopefully, God willing, we are meeting on Monday. And that Monday, we should, just like we did today, we will run through incorporated trustees and business names. because you will meet it in law school. Then the other day, which will be Wednesday, God willing, we will look at liquidation of companies. Are you with me? When we are done with liquidation, then if we have time, we'll now meet to just discuss. Remember our fasting and program. For now, it is 23rd of April, which is a Friday. Close out your diary on that day and pray towards it. I want to see, I will see some of you after the class. Thank you very much. God bless you all.